Cassandra. Let's start.
Good morning, good afternoon, good evening, everybody. I'm Cassandra Fernandez, Legal and Project Manager at the Global Lottery Monitoring System. And for the purposes of this evening especially, I'm very pleased to be welcoming you to this esports webinar that is under the umbrella of the esports series of the Berkeley Global Society, the Entertainment of Sport and Institute, of which I'm privileged to be the chair, and more specifically, this webinar being organized by another very important and prestigious institute, the Institute of Arbitration of the Berkeley Global Society. So I'm here today to welcome you together with the co-chairs of the Institute of Arbitration, Flavio Peter and Matteo Bordoni, as well as our panelists who are fantastic in their fields, in the field of arbitration and with esports, and are going to be introduced to you in a minute. So just to give you the background and context, the esports series was launched last month with 2 introductory sessions, which can be still found in podcast on the BGS website. But they gave you an introduction to esports and also discussed the organization structure of esports events. Today, we're going to delve down the arbitration lane, the possibility of arbitration as a dispute resolution mechanism for esports disputes, but also whether it is the only solution, and are there any alternative solutions. So I'm very pleased to introduce you to the co-chairs of the Institute of Arbitration. So you have Flavio Peter on your screen as well, who is counsel at Wenger and Vielli Limited in Zurich. He's also co-head of the dispute resolution team and specializing in international commercial arbitration. Flavio is co-chair of the below 40 section of the Swiss Arbitration Association and co-chair of BGS's Institute of Arbitration over here today. The other person that I would love to introduce you to, who is the co-chair of the Institute of Arbitration, is Matteo Bordoni, who is a Supreme Court lawyer in Rome. He's also of counsel at Lucente International with a specialization in dispute resolution and international trade. So with that being said, I would like to leave the floor to Flavio, my alumnus of UC Berkeley, and have a great session. Thank you.
Thank you very much, Cassandra, for the nice words. Hello, everyone, and welcome to this third webinar, as mentioned, on esports and broadly mentioning dispute resolution. And we will find out over the course of the day whether we really need to go down the arbitration lane or whether we might have other alternative dispute resolution mechanisms that might be more apt for that purpose. But before we hand over to Verónica, who is going to moderate, and I will introduce her in a minute, I'd like to shortly introduce you to our panelists, and each of them will then obviously have a few minutes to really explain to you what they do, why they're here, and obviously proving why those are the perfect persons for today's discussions. I'd like to start with Mr. Emin Ozkurt. He is managing partner at Ozkurt law firms in Istanbul, Turkey. He is a CAS arbitrator. He is well familiar with sports law, obviously with arbitration, but also very much involved in esports. I mean, there's many more things I could tell about you, but we agreed that I'll give you the floor and you can expand as much as you want. We're very pleased to have you, and you have the floor.
Thank you, Flavio. Thank you, Cassandra. Thank you, everyone. And hello, everybody, and welcome. As Flavio said, my name is Emin Ozkurt. I am the managing partner of Ozkurt Law Office, which is located in Istanbul, Turkey. I'm an Istanbul University Faculty of Law graduate, and then afterwards I did my LLM. I got my LLM from Manchester University in International Business Law. Right now, as we speak, I am the Turkish arbitrator at the Court of Arbitration for Sport, and I'm an independent legal and sport consultant. Also, I am one of the 9 founding arbitrators at the newly created EuroLeague arbitration panel, namely as EuroLeague Basketball Dispute Resolution Chamber. During my career, guys, I have represented many clients in my cases before the FIFA Dispute Resolution Chamber, UEFA disciplinary bodies, Basketball Arbitral Tribunal, which is VAT, Court of Arbitration for Sports, Swiss Federal Tribunal, and also naturally before the Turkish sporting bodies. Moreover, I am the legal director of the Turkish Esports Federation. I drafted the regulations of the Turkish Esports Federation and kind of trying to lead the legal scene in this field in Turkey. And today, as Flavio and Cassandra introduced, we will discuss esports in sports law and resolve the disputes arising from esports law through an arbitration procedure, which I'm very happy to be in this conversation, in this webinar together with a good colleague like Jeffrey. Thank you.
Thank you very much, Emin. And with that, we obviously will look at Jeffrey Benz. Jeff is, he's pretty much an encyclopedia of sports law and arbitration. He's a mediator as well. He has published an abundance of articles on sports related, but also arbitration related issues. So he's certainly someone that we had to, try to pick, and we were successful for this esports webinar. He as well is also one of the, let me just get this right. He's an adjunct professor, not only at Pepperdine University, but also Madrid-based ISDE, and one of the COS arbitrators. So Jeff, the list is too long. So I just give it to you and you pick from what you want to say. Thank you very much.
Thank you for that, Peter, and also for Cassandra and Mateo's efforts to organize this. I started out as a marine insurance lawyer. So if you want to know how you get to sports law, you start out as a marine insurance litigator representing the London market. I'm not the only one. I actually did a webinar once where somebody else began with that as the topic. And in fact, that person even had grown up in my hometown, which was landlocked away from navigable waters in the United States. But yeah, I've been in and around sports law before it actually got written down in some ways. And I was an athlete. You can look it up. You may or may not believe it based on what you see here. I am presently in Santa Monica, hence the unkempt hotel room bed there behind me. But I'm resident in London. I'm an American lawyer. I'm admitted in 4 U.S. states, and I'm an English barrister, despite this accent. I commonly refer to myself as the M barrister because I'm so unlike, I think, most of my colleagues in that vein. But I've been a sports lawyer for at least 25 years, and I can say that it's been a fun, interesting, very chaotic at times, but nonetheless, still at the end of the day, very interesting ride. So I count myself lucky to be able to call myself this and do what I do. Emin and I have been able to serve on CAS cases together, which makes life more interesting too. But my career really in the sports area took off when I went to Couder Brothers as which at the time was one of the largest international law firms in the world. And then I was general counsel of the U.S. Olympic Committee, the largest and most successful national Olympic committee in the world. And I got bored at that job and left it and became a professional boxing promoter. So with my original sport being figure skating, and I was world ranked in figure skating. Moving into boxing was, well, let's just say not the normal career path. But having said that, I've also been a lawyer and executive in pro beach volleyball. I ran the US and Australian tours in pro beach volleyball, and a number of other things. But I've been, pertinent to this topic, I've been a champion for years now of the notion that esports needs to learn how to fight among itself. And that takes the involvement of the participants in esport, as well as the institutions on the commercial side for dispute resolution, as well as the institutions that are involved in the ecosystem of esport. And so that's why we're here today. I've been able to champion this idea in and around the West Coast of the US, and I'm hoping to take it further on behalf of an entity I work for, which is JAMS, and we've drafted a set of esports related arbitration rules that would be pertinent to competitions in real time in esports. And I think one of the things that we all know is that time is of the essence in sports. Somebody invariably will tell me when I ask, do you record your favorite sports competition events? And I laugh at them because that's not your first desired thing. Your first desired thing is to watch it in real time when it happens, knowing, just for example, that Chelsea won the Champions League when it won it. I'm not picking a team, but that might be my favorite one. And so the idea that you would record sport or do anything else drives a lot of dispute resolution in this area. And in esports, it's an even tighter time frame. So with that set up, I will move on and try to listen to my colleagues here too, while also contributing when I can. So thank you very much for having me.
Thank you very much, Jeff. Thank you for setting the scene. We can call ourselves lucky to have you, and we're looking forward to see how you will be, maneuvering around certain issues or championing for certain points that is yet to be seen and moderated by Verónica. I'd just quickly like to introduce all the audience to Verónica Esquivel Patiño. She's a senior associate with Sánchez DeVanny. She works in civil and commercial litigation, but also in international commercial arbitration. She's obviously a UC Berkeley alumna, and she is part of the Institute of Arbitration of BGS as well. At the same time, she is ICC YUF representative for Latin America and the current chair of ICC Mexico's Young Arbitrators Committee. Vero, as always, an absolute pleasure to have you with us, and we thank you for moderating this session, and wish you obviously and all the audience a lot of fun. I'll give you the floor.
Thank you, Flavio, and well, thank you to Berkeley Society for the invitation to moderate this great panel. And well, considering I have like a million questions to ask both Jeffrey and Emin, and that all of you who are joining us will probably also have some questions for our experts, I will be jumping right into my first question. And I think Jeffrey kind of set up the mood for this question when he said esports need to learn how to fight. So my first question for both our speakers today is basically setting up the context for this industry. I think it is of great relevance to ask first a question regarding the type of disputes that we may most often see in the esports industry. I don't know if Emin and Jeffrey, if you could, from your experience, discuss the most common disputes in the industry.
Well, I'm happy to cede the floor to Emin, but I can also answer it. But
yeah, Emin. Jeffrey, go ahead. Go ahead. I will follow you. Follow your
all
lead.
Right. So I think what you're most likely to see in the esports area, and unfortunately, most of the rules have not really been written in this area in terms of addressing the subject matter. But esports suffers from some of the same conditions that you find in on the field of play sports. So you have issues related to doping that come up. You have issues related to the movement of athletes between teams. You have relationships between the teams and the event organizers. Even if the ultimate adventure of competing in computer gaming is not the same as being on the field of play, many of the same issues come up, and these issues are sometimes addressed, sometimes not well addressed in the scope of what the organizers of events do, but they're all going to be addressed in the future because they're going to all result in potentially high profile, difficult decisions to be taken by people that are involved in organizing the sport. And one of the most fundamental parts of governance of sport and governance of the organization of sporting related events or events that involve competition is the ability of those events to take the heat out of disputes that are on the table and solve problems. And so I think that you'll see many of the same things that you see in the headlines you read every day about more traditional sports that go on in the world: football, tennis, volleyball, you name it. And those issues are going to be an issue for esports to come to the table and resolve. But as I mentioned earlier, I think the culture of dispute resolution is not quite there yet within the industry. Folks don't quite know how to fight with each other and get things resolved in an appropriate way. And part of that falls on the publishers, who need to help foster the system so that they minimize impact on the conduct of the events that they do. So I'll say that as my opening.
Yeah, if I may follow up, like many countries, esport legislation in Turkey and also in many countries, as I said, is not yet regulated like football or other mainstream sports. License, registration, visa, and transfer regulation of professional esport players were the first published regulations by the Turkish Esport Federation. And then the referee regulation and the competition regulations were followed. So there is a very huge lack of, big lack of regulation on this field. Also, if we need to touch on the specific dispute topics that may arise from esports, we can mention that within the scope of sports law, esport has different stakeholders from other sports fields. In the esport ecosystem, there are game companies with intellectual property rights rather than football, volleyball, tennis, or etc. To put it more clearly, esport is an anonymous game. There are as many esport branches as there are game companies. So frequently encountered disputes regarding esports in the field of sports law generally arise from the contractual relations. In the transfer agreement signed between the esport players and clubs in Turkey, for instance, there is no requirement for to form the contracts. So contracts violations of the parties, non-payment of monetary debts arising from the contract come to the fore in the sense of a dispute. Along with the contractual disputes, disputes regarding violations within the tournament organized by game firms come to the fore as well. So in this context, a legal debate arises. In violations that occur in tournaments organized by gaming firms, the game owner firm makes an independent judgment under its rule guide. So at this point, question marks arise because there is no institution authorized to supervise the proceedings of the game owner companies in that relevant game. So an excellent example of this may be the South Korea, because in South Korea, the prosecution of violations in the tournament, esport tournament, is carried out by an association that has been given special supervisory authority. So in addition to contractual disputes, sponsorship problems may arise with the increasing value and audience of esports day by day. For instance, internationally popular brands such as Red Bull, Intel, and Samsung are already aware of the value that reached by the esport market. So issues such as sponsorship agreements, the creation and marketing of advertising and promotion areas are amongst the most intense elements of the esports field, I believe. And another main topic that is kind of legally problematic or can be a dispute subject is the ambush marketing practices, because the ambush marketing practices are also one of the issues that keep lawyers busy most of the time in the esport industry, because due to streaming, copyright issues become legally problematic. For example, when you in the United States, Jeff will know better than me, but in the United States, streaming or public performance of a copyrighted material by electronic means is illegal unless authorized by the copyright owner. So this should be one of the main concerns on this field too. So a more technical issue that arises in the esport field is that I'm not going to go into the anti-doping issue because it's very common, very simple. It's the same issues that deals with WADA and the anti-doping regulations. Because, for instance, there is in this field there is a understanding that anti-doping regulations should be applied as well over here too, with the collaboration of WADA. And more specific dispute type that arises from esports, which I would like to mention, is the poaching. You see, the poaching happens when a player plays in a champion in a league, in an esport league, and is listed with the contract database, and who is later approached by another team or owner or management. When player accepts offer out of existing contracts, that will be termed as poaching. So there are some documents clarifying what constitutes poaching in some publisher companies' regulations. There are some documents clarifying what constitutes poaching under its guidelines, and all player contracts must be submitted for approval before being able to play in that competition. So what I would like to say is that these are pretty much the main disputes that arise in esports, very, very generally. And in addition, of course, whatever Jeff referred as in the traditional sports there are disputes, same applies in esports as well.
Thank you both, and this leads me to highlight two ideas that I think come from your answers. Firstly, the number of stakeholders and the different disputes that arise between them, and this coupled with what Jeffrey previously mentioned about the lack of dispute resolution culture in the esports arena, well, leads me to ask in more detail. What do you think about the dispute resolution culture to this date? And as a follow-up question, considering that the dispute resolution culture, as I anticipate from Jeffrey's previous answer, what would be, in your opinion, the best ADR mechanism or the ADR mechanisms, if any, that should be the primary choice for the disputes that you've been discussing? I don't know whoever wants to go first.
Yeah, I mean, do you want to take that, or I can take it? I can take a stab at it, and you can clean it up when I mess it up in my answer. But I think that I think that the obligation of all of us as dispute resolution lawyers is to bring to the table for our clients a robust and vibrant tool set in terms of helping our clients resolve their disputes. And I sit mostly now as an arbitrator and a mediator, and my clients are more like customers, maybe, that come to me for ripe disputes that are already there. But I think that being able to figure out what's the right mechanism to solve the problem that is in front of the clients that you have at least as lawyers or as participants in the esports environment, just like any other environment, is ultimately the most important thing. And that can include mediation, that can include arbitration, that can include hybrid issues, for example, like early neutral evaluation, or other techniques that have been developed to try to help disputing parties come to a solution. But I think that ultimately, esports is no exception to the adage that that you need to find peace among your issues, and sometimes to accomplish a good peace, you need a really good war. And there are different mechanisms to help you get through that. So on the commercial side, the publishers are very used to resolving their disputes when they're in commercial disputes with commercial parties they've agreed with, using arbitration, mediation, and the like. In fact, JAMS, which is an institution I'm part of, does a fair number of these disputes, even within the esports environment, in terms of resolving licensing issues, game development problems, and things like that. Where you get into a different area is, as Emin has alluded to, the area where you're dealing with relationships with individuals mainly, but also with teams, but players and teams. And how do you convince those folks that they need to find a way that forward that gets them out of whatever negative mode they're in terms of disputes with people they ultimately have to do business with, and gets them to a resolution. And that's where I think the opportunities of mediation and arbitration provide for are realized, right? So you can, if you look at any sensible rendition of the differences between negotiation, mediation, arbitration for resolving disputes, and you compare it to litigation, and at least I can do that with some confidence and competence in the United States and also in England and Wales, you're looking at a multi-year process in court. You're looking at a public process. You're looking at a process where you have the ultimate fact finder, judge, intermediary who doesn't know jack. He doesn't know anything about the specialized area that you're talking about. And you can overcome these hurdles within the arbitration and mediation schemes. So mediation is generally confidential. Arbitration is generally confidential until you have to enforce an award. But you can pick an arbitrator or a mediator that knows something about esports or about the industry, and you can pick someone that's bound by confidentiality, and they can't talk about the case. They can't talk about what's going on. So there are a great many benefits in the esports environment to using traditional alternative dispute resolution outside of the courts that I think apply with equal force as they do in the commercial environment, and hopefully soon the esports participants in that ecosystem will discover these benefits and understand that you can fight in that world, and you can come back and you can have a commercial relationship with your disputing party. In that relationship, you might have won, you might have lost, you might have gotten something in between, but you would ultimately be able to thrive, and disputes can be resolved quickly, and they can be resolved in a creative way, and you move forward. So I'm a big proponent of the use of traditional ADR in the esports environment, just like everywhere else.
Just before giving the word to Emin, I'm going to ask one more question so he can also address that. I'm precisely talking about this creativity in the ADR. If you could tell us additionally to these ADR mechanisms and what you consider the culture should be, if there are any needs and particularities that should be addressed in the esports industry by these ADR mechanisms. For example, I don't know, the central role of publishers that I think has already come up quite a few times in this discussion, or for example, how if it is possible to manage the risks of conflicts of interest, and how these particularities in the industry might be addressed through these ADR mechanisms.
Yeah, sure, Verónica. Yeah, after talking about in our first question about the disputes that may arise in esports, the question of how to resolve them, resolve the disputes, and which authority shall be authorized within the scope of esports are raised, as you did. And here we face gaps in the judgment of the sports field, because accordingly, arbitration can be considered as a good option to fill the judicial gaps that may arise in esports disputes. Because at the end of the day, arbitration is a procedure in which a dispute is submitted by an agreement of parties. So to one or more arbitrators who make a binding decision on the dispute. Basically, this is how the arbitration works. And arbitration can only take place if both parties have agreed to it. In the case of future disputes arising under a contract, also the parties insert an arbitration clause in the relevant contract. And this is, as we all know, as I guess our participants, we all know how it works. In sports law, I think, CAS is very traditional, looking at very traditional sports, but at the end of the day, CAS is an independent and binding judicial institution that serves international sports, and it is authorized to resolve all disputes regarding sports law as the fastest possible manner. So from my point of view, CAS can be applied for any dispute that is directly or indirectly related to sports, including esports. But the thing is over there, even in addition to that, it is also clarified in the jurisdiction of the CAS in the Article R27 of the CAS Code that in this context, if a dispute is related to sports and parties agree before or after the dispute arises, the CAS can have the final say. But the main problem, the main challenge we may have before CAS may be the level of understanding towards esports, because we have 400 or even a bit more CAS arbitrators in Lausanne. I'm one of them, but to be familiar with esports is very crucial to come to a just decision in a possible dispute, I believe. Therefore, we should also have people or arbitrators more familiar with esports and esports related disputes, so that when it is referred to the CAS, it can be well answered and just rightfully resolved. And in addition, for this reason, it will be legally healthier or procedurally economical to conduct esports dispute within the CAS, but it has to be also at a certain level of financial value, because CAS arbitration is not a cheap arbitration. It has a certain financial burden on the parties. So at the end of the day, if you're going to take a case before CAS, it should worth to be taking it there when you consider the value of the cost of the arbitration itself. This is what I can say about my opinion on this issue.
Yeah, and Emin knows that I'm less of a fan of the opportunity of CAS to solve these kind of cases.
I know.
Partially because the median age of CAS arbitrators is older than me, and I'm old. So I think that that's a big issue, and parties deserve to have people making decisions about their case that are like them, that look like them, that are thoughtful in the same ways they are, that think like they do about different things. And so for me to be in my 50s, and actually today is my birthday, another one, and I'm in my 50s, and I won't say how far into it, but as a champion for the use of dispute resolution practices that work in other fields in the esports environment, I have to say that I'm at the upper end of the range. And so Emin makes that very good point that you need to find the right place to put disputes and resolution of disputes in this area with people that know something about it, that are familiar with it, that you don't have to explain to, yes, actually, grandma or grandpa, they are watching other people play video games and they're doing what they're doing, or they're competing in playing video games. And you have to find people that know and have a sense of what is culturally appropriate within the dispute resolution environment. So non-contextual outcomes that don't reflect sort of the context of what you're trying to resolve this dispute in are usually not the most lasting kinds of dispute resolution outcomes in my experience, having done hundreds of cases as an arbitrator and mediator. I would say also that in esports, as I mentioned before, esports more than even the traditional sport, time is of the essence, and being able to respond in a very timely way and get things done in a timely way that doesn't impact the scheduling of competitions or the outcomes with dispute resolution that's happening in the background is very important. And an institution like CAS has some experience with that in the Olympic environment, but the notion that CAS might actually pull this off in the context of each individual publisher's World Championships qualifying and World Championships events is something I think even Emin, as a fan of CAS like I am, will be skeptical about. So I think that finding the right place to put these things, finding commercially minded dispute resolution people to solve the problems that are going to inevitably occur within the esports environment is a very important factor in this that the world needs to figure out. I'll put it that way. So.
Yeah, and I think you set up the floor for my next question perfectly. This requirement of time is of the essence, age-appropriate experts, people familiar with the industry. This leads me to ask, are the rules applicable by different institutions to arbitration? Do they meet the standard for this kind of industry? Should we think of new rules? I believe Jeffrey anticipated that there's JAMS rules drafted for this industry in particular. Do the current rules meet the standards? Should there be new rules? Should we think about expedited procedures specifically for this type of disputes, or what would be your opinion?
I mean, Emin, do you want to take that, or do you want me to?
I can take that, no problem. Let me go along with that question. Starting from we should focus on the international organization chart of the esports in order to reply to this question, I guess, because at the end of the day, there is still a big question mark on who is going to, be the leader of this esports sector or environment in the international aspect. Because when we have a look at the international area and the community of the esports, one of the most significant examples, one of the most significant structure is the International Esports Federation, IESF. So as you know, IESF is an organization based in South Korea, promoting electronic sports as a legitimate sport. And among the goals of the IESF are the activities to take esports one step further, such as increasing membership, global standardization of regulations, training, education of esports players, and so on. So in parallel with IESF, there is another organization which is called the Global Esports Federation. So that also promotes the credibility, legitimacy, and prestige of esports. So the Global Esports Federation is established more than 115 global partnership, including more than 90 member federation, international brands, publishers, developers, and strategic partners. The Global Esports Federation also prioritizes the developing of an inclusive, safe, healthy, and sustainable esport ecosystem with certain regulations. So this is still a big race in international aspect to lead the esport area in the international dimension. I think one of those organizations will be the leader of this area and will try to draft the solid regulations that will be applied later on the relevant countries. But in my country, let me give you a certain insight from Turkey. In my country, in Turkey, some arrangements have been made for esports, and which has become the focus of attention, especially among young population. Because in our country, esport is also rapidly developing, and we have reached the large masses in the esport community. From the regulation point of view, the Turkish Digital Games Federation was firstly established under the Youth and Sport Ministry in 2011. However, that federation was abolished later, but then the Turkish Esports Federation, which is now the head of Turkish Esport ecosystem in Turkey, was established in 2018. This is very important because the Turkish Esports Federation is the sole federation in the country which is recognized by the Minister of Sport, and the Turkish Esports Federation has also become one of the founding members of the European Esports Federation, which launched in February 2020 last year. So I think the phase by phase, the national federations, together with merging other international federations, will step by step create some kind of a bigger ecosystem, and later it will turn out to be like the FIFA, below it UEFA, below it national federations, and all the regulations will be harmonized in some sense. However, this is not very easy in esports. I mean, I'm in favor of this, but I have to tell or at least confess that this is not very easy, because you have to have the publisher on the side of the federation and make him agree to somehow delegate his powers to the federation to monitor it on some of its events, sporting events. So I see it very hard for some of the companies to get along with it. That's why some of the companies try to create their own regulation sets and also their own dispute resolution mechanisms. However, that is also a problematic approach, because at the end of the day, if you create a dispute resolution chamber within your organization, you're going to pay the fees of the deciders, the arbitrators or the judges, whatever you name them. So there will be a big problem of impartiality, and maybe at some point a conflict of interest in some disputes. So I think this is a long way to go, Verónica. We're all going to have to work more on this within the webinars like this. This is what I have to say about this subject.
So I would only add that I think that the publisher issue is the single most defining feature structurally of this industry. So FIBA does not own basketball. The NBA does not own basketball. People dribbling with a ball and shooting it in the net is not owned by anybody. It's owned by all of us. But Riot Games owns League of Legends, and it's their IP. And for me, I am much more cynical with the idea that somehow a company that makes well over $1 billion from their IP annually, and I think now it might even be a couple $1 billion for that particular game I mentioned, is ever going to delegate the power to regulate competition, regulate conduct in the space, in competition in that game, and the like, to a third independent party. I think that the idea that that's going to happen it's hopeful, and it might help with making regulatory simplicity, but I think it's extraordinarily unlikely. And you have basically 5 or 6 major publishers that dominate this particular space, and they treat their IP, their intellectual property, the game, as theirs. It's not basketball. It's their game. They made it. They invested in it, and they need to get a return for their investors in that game. And so ultimately, I think that as dispute resolution professionals, the space that we can inhabit in this environment is one, hopefully, where at least in the competition format that these companies put out and create, aside from their consumer-based business, and let's face it, League of Legends is a consumer-focused endeavor. The competition part of League of Legends is small relative to that space by any measurement that you take, economically, participatory, whatever you want to measure. But at the same time, this kind of competitive environment where you put people up against each other, vying for prize money, and then all of the other benefits that come from winning, like sponsorships, licensing, and the like, you need to provide them with a system where they can feel that they've been heard. This is what I do every day. Every day, I spend, doesn't matter the subject matter area in which I'm an arbitrator or a mediator, I try to let people be heard and make them feel like they've been heard. So they get closure at the end of the day to whatever the outcome is in their dispute. And so esports is really no different than this basic fundamental human kind of need. And finding the way to build that system and doing it is, I think, is where we're at in the esports environment now. So I could say we're at ground floor. I would say that the culture of dispute resolution in esports is probably one floor below the ground, right? They're like digging the foundation of the building right now. And as professionals in this area, at least for me, I'm trying to help them figure out how to do it in a way that brings peace. That's ultimately what we do. Ultimately, we bring peace, and that's no less important in esports than it is in any other aspect of life. So.
Yeah, and actually, I have a question from our audience by Audrey, following up on this, and precisely focusing on the role of the publishers. That I think we've gone through it quite a few questions. She asks, considering that there is no recourse to an external arbitration body, for example, decisions of a publisher, could they be appealed in front of civil courts? What is the current landscape regarding the situation with publishers? And for example, she mentions as an example the situation of Blizzard that has its seat in California. So I don't know if you could share your thoughts on this.
Yeah, Blizzard is just down the road from where I'm at right now in Santa Monica. But I think that the publishers started their life with developing the IP that they have around a game, and competition, I think, was generally a secondary idea and factor. And they live very much and very heavily in a commercial world. So, for example, to the extent that they do licensing agreements with third parties and have other contractual commitments commercially, Blizzard and Riot both include a jams clause. So you have generally, I've seen the contracts. You have a predisposition to pick your arbitral institution. Jams is the one that they pick in their rules. I can't say it's all of them, but I've seen enough to know that they have some disposition to this. If you don't put an arbitration clause in your commercial agreements, you're stuck with litigation. And so the idea to me, and I work with a bunch of retired judges within jams, and I say this to their face, the idea that a retired judge, who generally will be of the geriatric variety, that's a fancy English term, they'll be older, much older than me. The idea that they will be able to relate to what is going on in the esports environment in any significant way without education is a farce. Okay, so you have to spend a lot of time excuse me, when you get into the courts, even with trying to educate a sitting judge and if you're in the US, in California in particular, a sitting judge who mainly sees, let's say, personal injury cases or rental car disputes or landlord-tenant cases in state court, that kind of thing. Maybe they have a criminal docket where they get a few sexy and fun cases every once in a while. But the idea that that you're going to imbue this person with the power to know how to come out with the contextually correct outcome in your industry is a joke. It's completely naive. So I think that the commercial parties, at least in their commercial dealings, have figured out, well, we should go to arbitration and the like. What they haven't pushed down through the ecosystem is the notion that, for example, perhaps arbitration should apply to disputes between players and teams, right? And that in the United States, maybe not so much as in Europe, but in the United States, employment cases can be arbitrated. The idea that a commercial party wants to have its esports team-related disputes put out into the public milieu should be scary to them, because you never know what anybody's going to say. You don't know what's going to be alleged. You don't know what's going on. And at least in the arbitration environment, you get confidentiality. I think that there's a role for the courts to play here. I think that the best role that the courts can play is merely deciding whether to enforce an arbitration award or not deciding the merits of a case that involves elements that are very foreign to the typical judicial officer's experience and knowledge. So that's how I would answer that question.
If Emin doesn't have an additional comment, I would ask, because our audience, including Flavio, are going crazy with the questions, and I would take advantage to ask one question from Flavio. And it would be, in your view, and considering what Jeffrey just exposed, what would be more important in an arbitration? An arbitration who is experienced in arbitration, or an arbitrator who is experienced in the industry itself?
Well, I think the arbitrator makes the difference. In any kind of, firstly, of course, you need to have an organization, an institution who is reliable, which has a long history of sports-related dispute resolution, and the kind of notion which the arbitrators selected to that organization should be at a certain level. That's the first thing to come. And on top of it, because we are talking about esports, because esport is something particularly different from the other traditional sports, I think you need an arbitrator which has a rather different approach than the traditional arbitration mentality, traditional sports arbitration mentality. Because in esports, there are some technical points which are very crucial in order to understand the essence of the dispute. Of course, you can always have an expert opinion to support the case and to get the case understood better. But still, if you are not very much related to that technical point, you will still be in the limbo. So that's why I think we need both. We need a reliable arbitration authority, which an arbitrator is included in, and also an arbitrator who has some sort of not knowledge I would like, but if not, at least some kind of closeness to the matter at hand. Yeah.
I don't know, Jeffrey, if you would have something to add, or if I can add one additional question from my side. You're on mute.
Yeah, sorry, I failed the mute test there on Zoom. All I would say is that I think that all forms of dispute resolution the benefit of solving stuff outside of court with third-party providers, people that aren't the courts. The benefit is the flexibility. The promise of that dispute resolution mechanism is it's flexibility. And among the elements that are flexible, you can define in your arbitration clauses who it is you want to have be your decision maker or help you resolve your dispute. You can define their characteristics, their qualifications, their background. I am more of the mindset, perhaps, than Emin is, that commercial institutions in the very heavily commercially dominated environment of esports are more suited to doing these kinds of things than the the traditional arrangements that have been made in sport, in international Olympic sport, for example, relating to solving disputes. So within the traditional sports environment, esports suffers from the fact that there's still an attitude that this is not sports because nobody's sweating, right? Nobody's like going out and doing, their heart rate's not going up necessarily the same way that other athletes are. And you still hear this debate about, is it sport or not? And to me, that's irrelevant. What's relevant is that you have people competing against each other in a head-to-head environment, and there's a winner and a loser. And that is the kind of thing that, in my experience, is innately resolved through traditional commercial mechanisms for dispute resolution. We've all done it. And so at JAMS, I have spearheaded the effort to launch our new esports related competition arbitration rules that have a very quick timeline, that have the application of a virtual panel and the like. And it's not very hard for us, based in California, to move from Orange County up the coast slowly to Seattle and talk to the publishers in an engaging environment. And this is a bit of a different discussion than what you find with the current structures that have emanated from traditional sports law and tried to put governance over top of esports in some way. And so I think it's a more commercially minded approach. I think that's the way to build the systems and the culture and the structure of dispute resolution that will benefit the esports environment. And that's the way to go, rather than imposing some external force that already exists, like on top of these publishers that are worth billions of dollars. Their IP is worth billions of dollars, and trying to convince them that they should pass that off into the hands of some third party where they don't otherwise have control. So I think it's the esports environment is much more commercially oriented. I think it benefits and has detriments as a result of that, but the benefits for dispute resolution, I think, are potentially significant in that commercial environment.
Thank you. And just to add, and I think it was mentioned on the previous question, the benefits of ADR to the industry, but are there any potential challenges we could see, for example, in the enforcement of awards in this industry that you can anticipate or that you have seen in your experience, considering the key players, stakeholders? Have there been, or could you anticipate there being any challenges to enforcement of an arbitral award?
Well, I mean, the single greatest development in this world in terms of uniformity of enforcement was in 1958. And those of everyone on the call here that might have gone through an American law school, you have to take civil procedure, which involves the procedures for engaging in litigation before state courts. And I think in foreign jurisdictions, you have to do similar courses. And at the end of the day, those outcomes aren't worth jack, as you say, because the idea that you're going to enforce a judgment of a court from Brazil in China or Germany or whatever, that's a nice, fancy idea, but it's not a practical one, and it's a very difficult endeavor. But we have the benefit of the fact that the New York Convention passed in 1958, which forms the basis, the bedrock of all of international sports dispute resolution, allows parties to agree to arbitration and arbitrate their disputes and have those awards be equally enforceable without discrimination anywhere in the world. And in the past year and a half, we've had the adoption of the Singapore Convention, which does the same thing for mediation outcomes. And I have great hope for this. I've written an article about my hope for the potential impact on mediation in sports of the Singapore Convention, because it is the New York Convention for mediated settlement agreements in terms of enforceability. But the notion that you're going to take these kind of cases to national courts and have consistent results around the world in competitions that are conducted internationally is a joke, as sports discovered in the mid 80s, early 90s, when CAS was in its formative stages. Like you need to really focus on having a specialized group of people that know the environment, that know the context. And I keep saying context, but they know what they're doing, so their outcomes will reflect the culture of the sporting environment in which they find themselves. That is very important, and that has not developed in a significant way, and it needs to be for at least for as we lawyers would say, for traditional dispute resolution to have any benefit. So.
If I may add,
yeah,
if I may add to that, Well, there are also some legal barriers in Europe and also in Turkey on that alternative dispute resolution matter, unlike United States, because the employment-related disputes in most of the countries in Europe, in continental Europe at least, cannot be decided by alternative dispute resolution body. It has to be the civil courts who has to deal with this matter. So even if a company, a publisher creates its own dispute resolution chamber, which it may render a decision between a player and its club on a contractual dispute, it can still goes to the civil courts to be challenged. So I'm not a big favor of civil courts, but at the end of the day, they are there, and at some point, they will like to engage to protect the civil rights of the individuals who are dealing with the esports. That will pretty much be the case in continental Europe.
So Emin raises a good point, but no law I know of anywhere in the world prevents mediation from happening.
No, it doesn't.
And mediation is always available as a way to resolve things. It may not be widely practiced. I mean, I think I've made the point publicly before that if you want to be a mediator in Switzerland, make sure you're a waiter, because you need to have a day job, some other form of income, because it's not widely used as a tool. But if you want to be a mediator in the UK or the US or the common law countries, and even in Matteo's jurisdiction in Italy, you have a bright and possibly successful future ahead of you in terms of people engaging in that as a tool for decision making. But yes, so certain subject matters are perhaps outside the purview of the arbitral scheme, but for the most part, there's almost nothing that can't be resolved through dispute resolution procedures that are available outside of the court system, and the courts are not well equipped in the esports environment, not well backgrounded, not well equipped to be able to do what needs to be done in a timely way. So I will continue harping on this and yelling and screaming about it, much as I've written before. But I think it's high time that the publishers take a real principled stand on how they structure their dispute resolution mechanisms within their competitive sphere, within their games.
Thank you both. And actually, I could go on forever asking questions, and we have more questions coming in from the audience, and I have pending questions, so probably we'll get back to you for a round two. But for the time being, I'm gonna leave the floor to Matteo, who has some closing remarks.
Thank you. I just want to thank you, the panelists. I was enthusiastic to taking part to this webinar. I believe that many questions are open, since we have to find an efficient way to settle the dispute on sport. And I found that the panelists are not unanimous, since maybe someone would prefer a third party, a third supervising authority, while other would be more open to a consumer-based system, maybe open to the right of defense and to the mediation. Let's see what will happen. Of course, time is of the essence in such a kind of dispute. Saying that, I just want thanks again the amazing panelists, the audience for asking questions, and of course also the partners that permit this event, in particular GLMs and integrity partner CSCF Foundation for Sport Integrity. I just take this opportunity also to anticipate that 6th of July we'll have another one-on-two with interview with Habib Al-Mullah on arbitration. So we will be very happy to share the floor with him in July. Thank you very much again.
Thank you very much, Emin. Thank you very much, Jeff. And thank you for the fantastic
Thank
moderation,
you.
Verónica. It was great to have you. And we look forward to what Verónica called round 2. And we'll see how that goes. Thank you all, also the audience.
Thanks for having me. Thank you.
Thank you.
Thank you, guys.
Bye-bye.
See you. Stay safe.
You too.